Further hearing the appeal, London Borough of Merton Council against Nuffield Health Limited.
Yes, Mr. Kalinsky.
May it please the Court, you'll recall yesterday I covered the factual points, the statutory construction, the statutory history and background, including the Pritchard Committee report and the main rating cases. That leaves me today to deal briefly with Section 5 of my submission's implications and Section 6 picking up some response to the appellant's case. Before I do that, can I just deal with one loose end from yesterday? My Lord Briggs asked about the position in relation to charity shops prior to the Oxfam case, and you may recall I indicated I thought it was dealt with in the judgment. Can I just give you the reference that deals with that, which is it's right at the bottom of 859 and on to 860, and it records that after the passing of the 1961 Act, it was generally assumed by rating authorities that Oxfam shops were entitled as of right to 50% relief and eligible for further discretionary relief.
Sorry, could you give me those two page numbers again?
It's 859 at letter H over to 860 at letter B. So that was the assumption, and then it then goes on to say, in the light of certain observations made by Lord Denning and Lord Justice Wynne in Aldous, and an opinion of counsel circulated and obtained by the Association of Municipal Corporations, a number of authorities have recently taken the view that Oxfam shops do not qualify for relief, and therefore a test case was launched by originating summons.
Thank you.
So I've got 2 points to deal with under the implications. That they're both dealt with in my written case, and so I can take them, I think, relatively briefly. The first one is under the heading of coherence, and I address this in our written case at paragraphs 62 to 71 by reference to the example that Lord Justice Nugee gave in the Court of Appeal of the multi-schools. And the purpose of that example...
Can you just give me a page number?
For the case.
The bit in your case, yes.
Yes, forgive me, sorry. It's...
109.
It is at, yes, page 109.
Yeah, thank you.
And so the example is a single charity that operates from 5 sites or 5 schools, a multi-school charitable trust. And the purpose of the example is to assume that they are delivering sufficient public benefit overall of the type envisaged expressly in the Independent Schools Council case at paragraph 196, category B and C. And if I could just take that very briefly, just to orientate the example in the case law, the nature of the benefits that I have in mind. This is at page 951 of the bundle. B, arrangements under which students from local state schools can attend classes in subjects not otherwise readily available to them. And C, sharing of teachers or teaching facilities with local state schools. So if you envisage an example where the way in which the fee-paying school delivers public benefit across its suite of activities by undertaking that type of work on a significant scale and coordinating resources from the 5 schools. And so therefore we're assuming in the example that it's of sufficient scale to meet the charity law requirement across the activities of the single charity. And the point is that if they alternate where that productive activity takes place, then each site would, on the council's analysis, be eligible for relief. But if the same or a greater intensity of provision was provided at one school, what would result would be the arbitrary position that only that one hereditament would get relief on the council's case, despite the fact that the other schools were contributing resources. And in fact, the claimed purpose, so that's not sensitive to the claimed purpose, but I would submit that in fact the implications of the way the council puts its case go even further, that if instead of being an on-site provision, it was arguably the more beneficial off-site provision, so that the resources went out into the field to deliver the state-of-the-art Saturday school actually where it's needed rather than on the hereditament, then the council's case, as I understand it, isn't sensitive to that eventuality. So insofar as the point is claimed that their approach is supported by public benefit being the key policy simpliciter, I say it actually doesn't work when one thinks about how it creates anomalies and arbitrariness, which actually defeats the object that's claimed of it.
I mean, in many ways, I suppose it could be said that this is illustrative of what I think you would say is the mismatch between the public benefit test, which is directed to the activities of a charity as a body, and trying then to apply it site by site to individual hereditaments. I mean, the public benefit test is specifically aimed at the first, and is you would say inapposite for application to the second.
Yes, and that's I would essentially say for three reasons. One is it creates the complexity and the anomaly. Secondly, that it's contrary to the alignment that was anticipated in the Pritchard report. And thirdly, as Lord Justice Nugent perceptively appreciates, it actually encourages inefficiencies of delivery rather than optimisation of benefit.
Implications, yes.
So, my lords, I just say that as a sense check of the council's approach. That's my first point on coherence. There's a separate point, and I say a forceful point, on workability and impracticality. And if I could just deal with that very briefly. Again, that is canvassed in our written case at paragraphs 81 to 83, the reference being 114 in the electronic bundle. And as for the reasons I've submitted, the council's approach is a bespoke approach to public benefit unknown to charity law. Now, the minority approach of Lord Justice David Richards, as he then was, I submit, leaves us with a different inquiry. As I understand his approach, it creates a hard-edged question for numerous individual rating authorities and ultimately the court to determine. You can see that from paragraph 81 of the judgment at 150. And although that's a paragraph that relates to ground 3, which is issue 2, it's the only place that you can get any sense of how that minority approach could work in practice. And it's a hard-edged answer for the authority and ultimately the court. So that leaves the practical implications of each billing authority becoming, in effect, a quasi-charity commissioner on the new hereditament-specific public benefit test. And as Lord Leggett observed, there is obviously, self-evidently, the scope for inconsistent decisions to arise. And one of the key vices of the minority view in the Court of Appeal is the absence of any guidance as to how those criteria would apply in this new variant of the public benefit test. I submit we are left with all the complexity and nuance that the Independent Schools Council case illustrates, but none of the restraint, apparently, because the Independent Schools Council case was saying that there was a great deal of deference to the trustees as to how they would choose to implement that. But that deference, it would seem, although it's not entirely clear, is lost in paragraph 81 of the Court of Appeal's decision in the decision of Lord Justice David Richards. And in any event, there is this extra layer of trying to tailor a public benefit test to a subset of the activities of the charity that is remote from the actual way in which, in the real world, the charity is seeking to further its purposes. So I say it is impractical in its own right. Now, The argument logically stops there, but your lordship should also be aware that there's a practical impediment to creating this impractical issue, which is a jurisdictional point, or a forum point, if I can put it that way, because the only answer to this potential problem offered by Lord Justice David Richards is that in the usual way there could be authoritative rulings. He says that at paragraph 38 of the Court of Appeal's judgment. But actually seeking and obtaining authoritative rulings in this area is very difficult for a procedural reason, which is these issues arise in the magistrates' court on enforcement proceedings in the usual course of events, and the only appeal from that is an appeal by way of case stated to the High Court, and there is a rule in, and I set this, the actual statutory provisions are at 1252 of the bundle, but the basic point, we can look at them, but the basic point is you can't appeal from case stated to the Court of Appeal. The case stated is final, so the position is we would be opening up an impractical course where it would be, in the ordinary course of events, extremely difficult to obtain an authoritative ruling other than from the High Court. And if one creates different judgments at High Court status, it is very difficult to take them further, because if they start in that way, they simply can't go further. And the divisional court in the Kenya Aid case, paragraph 56, I'll just give you the reference, 1306, they depreciated the attempts of the charity in that case to say, we're appealing by case stated, but we're also going by judicial review. The reason for the judicial review is simply that this is an important case, and it might be that it needs to go to the Court of Appeal to get an authoritative ruling, and the divisional court said that wasn't a permissible use of judicial review. So there is a real practical impediment to obtaining authoritative rulings in this area. Now, that's not a reason in itself. The main submission on impracticality is this simply won't work at local level, but actually that is a further practical consideration that I do ask the court to bear in mind.
Is that one in your case?
Yes. So so the Kenya Aid reference is in. So I deal with this at 82. Paragraph 82 on 114.
Oh, I've got it, yes.
Yeah, the actual reference to Kenya Aid isn't, but that's in, Kenya Aid is in the bundle, and it's paragraph 56 of Kenya Aid at 1306.
Yeah, I've got that, thank you.
And so I make the obvious point that this would leave us, I would say, with a perfect storm of complexity, giving rise to likely anomalies without ready access to the appellant court, and that is really the exact opposite of what the Pritchard's report set out to achieve in paragraph 65 when it set itself the objectives that it did. And so I therefore say that Lord Justice Nugee was right in the observations he makes in a characteristically understated way at paragraph 149 to 151 of the judgment. That's 166 to 167 of the bundle. So that's my fifth point of the implications. I say also, by contrast, our approach is simple. It's simply apply the established position in charity in a way that makes sense of the statutory provision, and it creates no difficulties. And if it creates a situation that the person in the street might think surprising, well, that's a consequence of the way in which the relief was set up, and it was faced deliberately at the moment of the Pritchard report, and the parliamentary intention since then has been to continue to enact that, and the only indications are actually expansive, because you've got the Oxfam broadening of the relief, and you've got the increase from 50% to 80%, leaving the test unchanged. Then the final section is just any points that I haven't already covered that my learned friend Mr. Gowdy relies on. And again, I suggest that most of the points I wish to make in relation to those points are set out in the written case. So I'll give the references, but just explain the points briefly if it assists to do so. So the first heading is the relevance of unoccupied rates. And the reference to my written case is paragraph 54 at page 106. And the short point is I submit there is no relevance to unoccupied rates for present purposes. As this court analysed cogently in the Rossendale case, the position in relation to unoccupied rates has its own discrete policy basis, effectively securing the use of property where it's inefficient for it to be left empty, and that was the identified purpose that Parliament had for unoccupied rates. Chronologically, the key moment for us is 1961, when the 1961 Act was implemented, I say giving effect to the Pritchard recommendations, save in relation to universities. At that moment in time, there was no such thing as unoccupied rates, which came in from the Local Government Act of 1966. And that chronology is set out in Rossendale, paragraph 22. That's 1097, 1097 of the bundle. So, in terms of understanding the original rationale, it just doesn't affect it. And then, if we think about the occupied rates and charitable relief, we've got 1961, we've got the consolidating position in 1967, and then we've got the reenactment in 1988. When it was reenacted in 1988, it's fair to say that unoccupied rates did exist, but there was no relevant reference to charities, because the only relevant reference to charities comes in when the reach of unoccupied rates expands in 2008, and just to help, it expanded by increasing the properties which would be eligible for unoccupied rates to bring all industrial properties within it, also upping the rates, the basic rate of unoccupied rates from 50 to 100%. And at that point, zero rating for charities was introduced, section 45A that you were taken to, but that was in 2000, by the 2007 Act, having effect from 2008. So obviously after all the relevant enactments for present purposes, and that provision looks forward to the position we're next in use. My submission is its existence doesn't really help this court to understand the position in relation to unoccupied rates because of that chronology. But I do say, although it's not in any way a necessary part of my argument, but I do say that actually the alignment with charity law is likely to be simpler for the application of that test. But I don't trouble the court with any detailed submissions in relation to that. But the key point is, if one's trying to understand the purpose for which this provision was introduced into the statutory scheme, unoccupied rates are an irrelevance. The second point is the suggestion that this is an exemption, and as my Lord Legate observed, that's not how it's phrased in the legislation. We've got section 51 giving effect to Schedule 5, which is full of the patchwork of exemptions, which are the current versions of the patchwork system that was commented on by Pritchard. And mandatory charity relief is really different from that. It is a relief that is intended to be broad, it's intended to be of general application. Yes, it has conditions, but when those conditions are met, there is, as of right, a different approach to liability, which in the current scheme is introduced in the provision that introduces the liability. So my submission is it's better understood as a generally applicable alternate form of liability rather than an exemption. And my lords, I rehearsed that argument in paragraphs 55 and 56 of the written case at 107.
I asked Mr. Gowdy if there was any non-European authority for the generally narrow construction of exemptions. And his, I think, response, bitterly on his feet, was, well, there's nothing odd about the European principle, and it's what's good for them is good for us.
Yeah.
Do you have any response to that inquiry?
So I'll answer that in just a moment. I mean, it's strict rather than narrow, and I think those are different because you give it its obvious meaning, which may be wide or narrow. So I don't accept the proposition that it's a narrow approach, but I do accept that it's formulated as a strict approach. The only domestic authority that I'm aware of is the one that is dealt with in the appellant's case, and I respond to in our written case, which is the Iceland case, which was a decision of this court on a completely different part of the rating scheme, and that was to do, I discuss it in paragraph 56 of the written case on page 107, but basically that was to do with a valuation assumption. So it was to do with plant and machinery at a retail store, and the issue was that plant and machinery to count for the purpose of valuation. And the way the scheme works is you assume that the plant and machinery is generally excluded, and then there are classes to be included, and this case turned on a proviso to a class in the schedule, and the Court of Appeal approached it on the basis that it was a narrow exception, and the Supreme Court said, well, it's not, when you understand the provision, it's not an exception at all. It's a proviso to an exception to the general rule, but it doesn't deal with the point that this should be strictly construed. What it actually does is it unpacks the history and it shows where the provision came from, and it takes the flavour of how it should be approached from a detailed understanding of the statutory history. So I'm not sure that it takes my Lord Briggs inquiry further, but it does illustrate how these issues have been grappled with in a rating statute, and my submission is the key point here is to get if the words don't give one right answer, and I submit we're here, so they clearly don't, and the majority are right about that, then one looks at the background, and the equivalent inquiry to what found influence in the Iceland case is, in this case, to understand Pritchard, I submit. The final point is my learned friend deals with two cases that he say help him on public benefit. That's the Henning case in the House of Lords and the decision of my Lord Sales in the High Court in the Public Safety Trust, and I'll deal with those very shortly. Again, the points are actually in the written case. So Henning I deal with at paragraph 58 of the written case at page 108, and the short point is this is about a religious exemption. It's not about mandatory relief. We have a very broad observation by Lord Pearce based on the statutory scheme in issue in that case, which in fact predates 1961. So it's an observation on the patchwork rather than the post-1960, the post-Pritchard statutory scheme. And in any event, the question in that case was whether the Mormon Temple in London was eligible for religious exemption as a place of public religious worship. The answer was it wasn't, because it wasn't open to everybody. You needed to have a recommend to take part in the activities there, the ceremonies there. But the position is that there's no reason why that doesn't qualify for mandatory charitable relief. Henning itself is silent on that, but as my Lord Sales might recall, that was relitigated at a later point in time in relation to the Preston Mormon Temple, and there was a human rights dimension to that argument, and as I've put the references in the case, but the whole argument proceeds in a way that was actually critical to the claimed discrimination on the premise that the church was in fact receiving mandatory charitable relief. So Henning doesn't assist at all, because it's an exemption, it's a different statutory scheme, very broad observations about the scheme before Pritchard, and in any event, actually, substantively, mandatory charitable relief was actually in play, and the only issue was the exemption question. So that's Henning, which I say doesn't take us anywhere. And then there's the observations of my Lord Justice Sales at first instance in the Public Safety Trust at paragraph 34. Now, the issue in that case was whether the extent of the use was relevant under section 43. That was a contentious point there, and it was resolved by my Lord Lord Sale sitting at first instance, that it was, and that was consistent with the Divisional Court decision in the Kenya Aid Programme case, and the observations that are made in paragraph 34 arise in the circumstances of that case. They are general observations, which are entirely uncontroversial as general observations, but they obviously don't illuminate the issue in the present case, because there was no submissions about how, if at all, public benefit was to be assessed. And as I say in our written case, at paragraph 34 at 882, both sides' submissions in this case are consistent with the proposition that the mandatory relief applies when the premises are occupied for public benefit. The only issue is how you assess that public benefit, whether it's consistent with charity law or it's a counterfactual hereditament-specific assessment. And so those observations just simply don't touch on them, and it's no part of my argument to say that that was wrong. Those are entirely correct general observations. They simply don't deal with the point because it wasn't an issue in that case. So, Lords, those are the points of response. If I just very briefly draw the threads together, I submit as follows in relation to issue 1, that the court is faced with a novel proposition that there should be a hereditament-specific public benefit inquiry. I say, firstly, that doesn't reflect the better reading of section 43.6. Secondly, it wrongly imports into section 43.6 an unknown variant of the public benefit test, which is inconsistent with settled charity law. It does so in a way that is in fact illogical, because it doesn't have regard to section 4.3 of the Charities Act of 2011, that public benefit means public benefit as established in charity law. The approach is at odds with the settled approach in Glasgow and Oxfam of looking at the use of the hereditament that the charity in fact makes of it, and taking account where relevant to that understanding of other activities of the charity, to consider whether the use of the hereditament directly relates to the achievement of the objects of the charity. And it wrongly imports the counterfactual approach of pretending that the property is used by a single hereditament charity when in fact it isn't. And that by doing so, it would lead to a result that's entirely the opposite of the simplicity, ease of administration and alignment with rating and charity law for which the Pritchard report was striving when it introduced the provision in identical terms to the one that my lords are now having to construe. And so for those reasons, I submit on behalf of the respondent that Lord Justice Nugie's analysis is sound. Lord Justice Peter Jackson was right to agree with it, as he did in paragraph 89, 151. That's the majority analysis, and I say it is to be obviously preferred to the analysis of Lord Justice David Richards. So, my lords, unless there's any issue that I can assist the court with, those are my submissions in relation to issue 1.
Thank you very much. Mr. Gowdy, you're going to reply on issue 1.
Yes, Lord, I may. Lord, there is, we submit, a gaping hole in the respondent's submissions. We suggest that they fail to engage adequately, if at all, with an essential element of the public benefit requirement for charitable purposes, very well established in charity law, that the poor must not be excluded, that those of modest means must not be excluded. And this appears conveniently from the judgment of Lord Justice David Richards at EF 144, running over to EF 145, from paragraph 60, which is expressed by reference to Lord Wilberforce in the Privy Council in the private hospital case of Resh's Wills Trust, which is in the bundle of authorities. But, my Lord, I don't think I need to go beyond what Lord Justice David Richards says. In paragraph 60, he says, in order to be for the public benefit, the relevant services must be provided to the public or a sufficiently large class of the public, and the poor, the meaning of which I will refer to below, must not be excluded, and says that by that stage the leading case was the decision of the Privy Council in Re Resch's will trust concerned with a private hospital run by a religious order. And Lord Justice David Richards refers to the judgment of the board that Lord Wilberforce delivered, and Lord Wilberforce, but this is paragraph 62 of Lord Justice David Richards, that while a gift for a hospital was prima facie charitable, a hospital would not be a charitable institution if the benefit it provides are not for the public or a sufficiently large class of the public to satisfy the necessary tests of public character. It was objected that the private hospital in question did not satisfy this criterion because it provides only for persons of means who are capable of paying the substantial fees required for admission. The objection was not that benefits were provided to people who were not poor, but that the poor were excluded from participation in its benefits. And on the facts, that was rejected, and it was found that they were not excluded from the benefits, in particular in paragraph 63, in the quotation from Lord Wilberforce. It cannot be shown, the charges are not low, but the evidence shows that it cannot be said that the poor are excluded. So, my Lord, there may be issues as to whether or not the poor are excluded, but whatever else one does, one cannot have a health charity that is operating in a way which excludes the poor. My Lord, in our submission, that is fundamental.
In Re Resch, the Sisters of Mercy they were a multi-site charity in the sense that they ran two sites, the public hospital and the private hospital. But the question was as to the validity of a gift solely for the purposes of the private hospital, wasn't it?
Yes.
Yes. So I suppose the court had to look at it as if it was a single site charity to see whether that gift was valid.
Yes, yeah. I would think so.
I'm just making sure I've correctly understood the facts.
Yes. I mean, that corresponds with my understanding of the rather complex facts on that occasion. But it was necessary, therefore, for the court to consider whether or not there was an exclusion of the poor. And they found there wasn't, in fact, in the circumstances of that particular case. But it was a fundamental requirement, and of course this goes back to at least the 19th century, that the poor should not be excluded, and that is an essential element of the public benefit requirement. Lord, I have a small number of other points in reply. First, the Pritchard report in 1969. Second, our alleged inconsistency with charity law. Third, the statutory presumption of charitable status and what that covers and what it doesn't cover. Fourthly, the respondent's case being inconsistent with charity law. Fifth, Glasgow and Oxfam in the House of Lords. And sixth, from this morning, the implications. My Lord, the Pritchard report we submit is ultimately of very limited assistance, really for the reasons given by Lord Justice Nugee. That's paragraph 144 of his judgment. He took from it only the general point that the aim of the legislation was to produce uniformity and certainty and be practicable to operate. And that, we say, although obviously very welcome, provides little, if any, assistance in deciding between the competing interpretations which are currently before the court. The context, of course, addressed by the Pritchard report was one in which historic inequalities of approach had been frozen in place and compounded by the Holding 1955 Act, and the uniformity and certainty required was thus uniformity and certainty of approach, and that's achieved, we submit, on either construction, either interpretation of Section 43(6)(a). The Pritchard report indeed clearly acknowledged that a site-specific assessment could be required where premises were occupied by a charity. That's paragraph 95, which your Lordship has seen, cited by Lord Justice Nugee. This implies that some premises may benefit from relief while others will not, depending on the application of the test. That is neutral as to the content of the test, which is to be applied in the requisite premises-specific assessment. My Lord, subsequent...
You accept that goals of the legislation were simplicity and certainty?
Certainly in major part, yes. But total clarity was not achieved nor attempted. The clearest approach would have been obviously simply to grant relief to all properties occupied by charities, that's nice and simple at least, or to none, equally beneficial in terms of simplicity, however open to criticism on other grounds, and that was conspicuously not the line taken, no doubt for what were perceived as being sound policy and or political reasons. Procedurally, a degree of clarity was being sought, but as a matter of substance, some intra vires uses by charities would be benefited and others would not. What matters today is the substantive legislative purpose rather than the procedural one. The point with the legislative history is the change from the pre-Pritchard 1955 Act to the post-Pritchard 1961 Act, requiring use for charitable purposes rather than uses generally, and confining mandatory relief to charitable purposes. So the requirement becomes more focused in conjunction with greater entitlement to relief being conferred. A charity was not automatically entitled to relief in respect of activities on premises which did not themselves provide any public benefit, including not providing a public benefit because of there being an exclusion of the poor. So that, we suggest, is the substantive legislative purpose of the current provisions, to provide mandatory relief in respect of the use of premises which provide public benefit, and in order to do so, do not exclude access by those of modest means. It's an important point that benefit to health is not of itself enough to constitute public benefit if there is an exclusion of those of modest means. And, Lord, with regard to the Pritchard report, yesterday afternoon, our learned friend made essentially 4 points, as we understand it. First, that charities should have a generally applicable concessionary regime. Secondly, that the intention was for relief to align with rather than depart from charity law. Thirdly, that relief should be simple, easy to administer and certain. And fourth, the essential distinction was between occupation for its purposes and holding property as an investment. Lord, in the context of Pritchard, the first 2 points, charities should have a generally applicable concessionary regime, and that should align with charity law. Those relate to the definition of the class of organisations entitled in principle to mandatory relief. So that doesn't help us for present purposes, where the basis of the entitlement is being a charity, where the body concerned is a charity, but where the relief is on the basis that being a charity is a necessary but not of itself a sufficient condition for the rating relief. The first limb of the test for relief was met, namely that the ratepayer must be a charity, but that's only the start of it. And insofar as the second point, alignment with charity law, is said to support the respondent's case more broadly, we say that our case does not give rise to any inconsistency at all with charity law. The respondents say that it does, and I will elaborate shortly on both these aspects, namely whether our case is inconsistent with charity law and whether theirs is. The third point, that relief should be simple, easy to administer and certain, obviously desirable so far as that is sensibly practicable, was undoubtedly an aspiration expressed by Pritchard, but crucially by reference to the totally chaotic jumble of discretionary release that existed at that time, and that indeed by the time of Pritchard were frozen in place, and that was the situation existing at the time of the Pritchard report. Now, a clear and uniform test such as we contend for satisfies that criterion just as well as any other case. The fourth point, the distinction between occupation for the charity's purposes and holding property as an investment, in our submission that doesn't quite reflect the wording of Pritchard. Again, it's the paragraph 95, which your lordships have seen. It suggests that properties should not benefit from relief if they are held, for example, as an investment. And that paragraph is neutral as between the competing interpretations and doesn't indicate that the non-entitlement to relief is confined to investments, and one knows that it doesn't apply either to money raising, and that's not to say that the categories are closed. What one does know is that a head office will generally be on the other side of the line.
Sorry, which is the other side?
The side of the line where there is an entitlement to mandatory relief, either because the property is being used for the purposes, the charitable purposes of the charity, or because it, as in the case of the head office, it's being used as ancillary and directly facilitative of the activities that are directly facilitative of the purposes of the charity, which does not include, for example, properties held as an investment or properties held for fundraising purposes, as in the case of the Oxfam shops. So, my lord, that takes me into our next point in reply. That is the allegation that we are inconsistent with charity law in some way. They argue that our case, and indeed Lord Justice David Richards' judgment, is inconsistent with the meaning of public benefit, as that concept is understood in charity law. In particular, the asserted propositions that whether a charity is operating for the public benefit has to be assessed across all its activities, and that the advancement of the health or education, for example, of the fee-paying rich is itself for the public benefit. And given that Section 4, subsection 3 of the 2011 Charities Act, which requires public benefit to have the meaning that it has in the law of charities, they argue that our case is therefore logically contradictory. In other words, they suggest that we seek to introduce, via Section 4 of the Charities Act, a concept of public benefit alien to charity law. And my lord, as I've observed earlier, it is the reverse of alien to charity law, that public benefit is not fulfilled, even if there is an element of public benefit of a health or education or whatever kind, if there is an exclusion of the poor from the benefit.
That much is common ground. The point taken against you is you have to review that by looking at the whole of the charity's activities.
Well, my lord, depends on the context. Certainly there will be situations in which one will be looking at the whole of the charity's activities, and if the Charity Commission is looking at whether a body should be registered as a charity or not, whether a court was looking at whether an unregistered charity was a charity or not, then necessarily one would be looking at the overall position, and in particular the objects of the charity as appearing from its constitution or other constitutional document. But that doesn't exclude the possibility in, for example, a rating situation, given the nature of rates, that one also needs to consider whether public benefit applies in relation to the activities at and the use of a particular set of premises that constitute an individual rating hereditament. And
I suppose you can rely on Resch in a way as an analogy if what was necessary there was an assessment of the single site, because that was where the gift was given to.
yes,
You can say that, well, rating, on your case, rating operates like that.
yes,
And you have to make an assessment of the single site.
yes, which undoubtedly you do have to do. So it's not the rating authority making an assessment that it otherwise wouldn't be making at all. It's having to make an assessment of the individual hereditament, and the question is what is embraced in that assessment. And public benefit in our submission is at the fore. And
I don't think the Sisters of Mercy were a charity as such, were they? They were presumably an unincorporated association.
yes,
Carried out various activities, some of which may be charitable and some not.
yes, I mean they were a religious order, and a religious order itself may not necessarily be a charity in its own right.
Plainly they weren't a registered charity, but that's a separate question. Yeah.
No, but they didn't need to be that necessarily. My Lord, what we say in response to the way it's put against us is that as to whether a charity is operating for the public benefit, the duty of charity trustees, their fiduciary duty, is to operate a charity for the public benefit, but that's not an aspect of the meaning of public benefit in charity law. Rather, it's simply an aspect of the duty of a charity trustee to manage and administer the charity in accordance with its constitution. It's in this context of upper fiduciary duty that, for example, in the independent schools case, particularly paragraph 239, the upper tribunal held that whether a charity is operating for the public benefit must be assessed across its activities. The position is necessarily different, however, in the context of rates, because that is focused on the use of a specific hereditament. And then it said against us that the use of a hereditament to provide only for the well-to-do is use for the public benefit. But that argument is not supported by the respondent's second full proposition, that the advancement of health or education of the fee-paying rich is itself for the public benefit. To say that the advancement of the health of the rich may itself be for the public benefit is simply to say that the rich person is not outside the scope of the charitable beneficiary class, a sufficient section of the community, where that class does include the poor. Thus, the provision of benefit to the rich is not of itself a breach of trust or ultra vires. A rich person can be within the scope of the beneficiary class because a section of the community may, in the law of public benefit, be composed of both rich and poor. Rich, yes, but poor also, and provided that it is poor also, and that's where this present case differs. By contrast, the provision of benefit to the rich alone, that is, excluding access by the poor, is consistent not only with our case, but with charity law, not for the public benefit, because the rich alone are not a sufficient section of the community. A sufficient section of the community must include both rich and poor. And where the benefit is only to those of immodest means, because those of only modest means are excluded, then the entitlement to mandatory relief is not made out. And, my Lord, in our submission, this ties in with some of what is said in the independent schools case, in particular at EF 950. Or rather EF 955. Paragraph 214 of the Tribunal's judgment, there's an important distinction. This is an important distinction because it locates the failure to act in the public benefit as being the making of inadequate provision for access by and benefits for certain subclasses of the potential beneficiary class, the whole class being in that context the student community at large. It may be the case that if a school which fails to meet the public benefit requirement had instead made more provision for poor students, that would have meant that there was room for fewer fee-paying students. So some fee-paying students may be said to receive their education at the price of the school's failure to operate in accordance with its charitable objects. But it does not follow from that that the provision of education for the vast majority of fee-paying students is in any way beyond the school's charitable objects. In other words, even a fee-paying student would be receiving benefits, not as a member of some inappropriate class, but as a member of the general body of potential beneficiaries. And, my Lord, that ties in at EF 950.
Which page have you just been reading from?
955.
Thank you, I'm just running to catch up.
That's not a paragraph I think we'd looked at before.
That's 214, isn't it?
Yeah.
Yes.
Yeah.
And then, my Lord, the other paragraph is one that we have looked at before, which is at EF 950, and that's paragraph 195. In particular, the last sentence of that paragraph. So, my Lord, we resist any suggestion that our approach is inconsistent with charity law. Law, the presumption of charitable status
I still haven't understood the last sentence that everybody keeps referring to. How can the education of fee-paying students be the fulfilment of a public benefit requirement if the activities viewed as a whole do not satisfy that requirement?
Lord, that sentence is one of a number in this judgment, which.
Yeah, well, you just cited it to say that you rely on it. So
I was drawing it to the court's attention as part and parcel of the explanation which one can derive from ISC and elsewhere, that, put crudely, there's nothing inherently wrong with benefiting the rich, but you mustn't deny the benefit to the poor. And if you do deny it to the poor, then albeit it's something beneficial, a hospital, a gym, a school, it won't be for the public benefit if the poor are excluded. But that doesn't rule out the being rich as well. And, my Lord, in our submission, that hangs together. Then the presumption of charitable status. The respondent argues that registration of an institution as a charity, that is under Section 37 of the 2011 Charities Act at EF 673, they argue that registration as a charity has the effect that its purposes are presumed to be for the public benefit, so that activity within its purposes is for the public benefit. And my Lord Briggs said in argument that paragraph 39 of the judgment at first instance, that there was no suggestion that Nuffield's activities overall were not for the public benefit, was simply the effect of its registration. But, my Lord, we say that on any view, Section 37 of the Act is not a presumption that the activities of a registered charity fall within its purposes. It is simply a presumption that an institution is a charity. And even if Section 37 gives rise to a presumption that the purposes of a registered charity are for the public benefit, which may or may not be so, it still would not give rise to any presumption about whether a charity's activities was within the scope of the purposes, whether a charity was advancing health simpliciter or for the public benefit. And clearly, no presumption about whether the use of a hereditament was for the charity's charitable purposes in an Oxfam sense. And, my Lord, in our submission, therefore, the statutory presumption does not assist the respondent. It simply goes to what's not in issue, that they satisfy the first condition for relief, that they're a charity, but doesn't go any further. And this ties in with the next point I seek to make, which is that it is the respondent's case that is the case that is inconsistent with charity law. Because we say that if the respondent were right and public benefit were to be assessed overall and only by the Charity Commission, then public benefit effectively falls out of consideration under Section 43(6) of the Local Government Finance Act, and that is obviously inconsistent with the meaning of charitable purposes. Firstly, a charity's registration as such, and its continued registration as such, does not mean that the Charity Commission is making or has made an assessment that its activities are for the public benefit overall. This is because a charity's activities do not generally affect charitable status. Either the institution's objects are, as a matter of construction, wholly charitable, or they're not. Second, the billing authority cannot sensibly assume that the Commission has assessed each registered charity and every unregistered charity's activities for public benefit. Lord, I gather that on the register taken from the Charity Commission annual report for 2020-2021, as of the 31st of March 2021, there were around 169,000 charities. That is a big number for an inadequately resourced regulator. Now, plainly, no regulator could plausibly carry out a regular assessment in this regard. And yet further, the Commission will not be examining what charges the charity is proposing to impose upon those to whom it will provide services, if indeed at the time of applying for registration on the basis of its memorandum of objects, it has got to the stage of formulating a charging scheme. So, my Lord, there is in our submission nothing implausible about a billing authority deciding issues of public benefit, particularly as on any view it has to do so in the case of unregistered charities. And so in our submission the presumption doesn't make any difference. And indeed an example of an unregistered charity, and also incidentally an example of a case going on case stated, is the Preservation and Promotion of the Arts against Greater Manchester Magistrates Court case, which is in the authorities before the court. A decision by Mrs. Justice Jefford, but of course a decision at High Court level can be by a divisional court, which can be constituted in various ways.
Sorry, and what page is it? Can you give me the reference for that case?
Oh, my Lord, sorry.
Or just the name. I've just missed the name.
It's the a rather long name, Crown Against Preservation and Promotion of the Arts against Greater Manchester Magistrates Court. And, my Lord, it's 1001, I'm grateful.
Thank you. We didn't go to it.
We don't, no, I don't think we do need to go to it. My Lord, penultimately, Oxfam and Glasgow, it's claimed that they support the respondent's case because they tell against a blinkered approach to the assessment of the use. We, of course, don't contend for a blinkered assessment. Our case is rather that the process of assessment has to start with the premises, but doesn't have to end there, because what the statute directs one to look at is the use of the premises, and consistent with both Glasgow and Oxfam, it is relevant to consider the use of other premises insofar as the use of the subject premises is ancillary or incidental to that use, but only when it is relevant to that. So that the reference here to cystic fibrosis is wholly irrelevant because it's not suggested that there is anything at these premises which in any way relates to that. And this, therefore, is a case of whether the premises do directly serve the charitable purposes rather than whether they're ancillary to that. And it was indeed very clear, not only to the minority but also to the majority in the Court of Appeal, that the respondent does not put its case on public benefit in terms of ancillary use. One sees that in paragraph 43 of Lord Justice David Richard, that's at EF 141, and in the judgment also of Lord Justice Nugee at paragraph 145, which is at EF 165. And the respondent cannot do so because it cannot demonstrate any link other than conceivably a financial link, which wouldn't suffice for their purposes, between what is done at Morden Abbey and on the one hand, and those activities done elsewhere which deliver the public benefit required by its objects. Lord, finally, implications in terms of coherence, workability, practicability. We address impracticality and confusion of regulatory roles paragraphs 75 to 79 inclusive of our printed case, that's EF 83 and 84. The reasons we give, no regulatory confusion or other impracticability, simply different people doing their different jobs in their different ways. And my Lord, a Magistrate's Court decision on enforcement can, of course, go to the High Court on the case stated, and a divisional court can be constituted, including even with the President and 2 Lords Justices when an authoritative ruling is thought to be appropriate. So there is a proper legal regime in relation to regulation by, insofar as one describes the local authority, the billing authority, the rate, the authority that's charging the rate. It is suitably accountable, including by that route. And my Lord, tying in with that, one example, certainly in the appellant's, the respondent's written case that was given of confusion or whatever, was that on our approach it was said that a single site fee-paying school which delivered exceptional outreach work off-site may not obtain relief. My Lord, we say what's much more likely as to the outcome there would be that the operation of the school would be very obviously and directly incidental and ancillary to the conduct of the public benefit generating activities. The school, in other words, would be analogous to a head office supervising charitable activities both on site and elsewhere in the case of a multi-site charity. We don't argue that an inquiry has to be limited to the activities taking place on the hereditament. We've never said that. But the inquiry, we do say, has to start with those activities, and then functional links can form part of the assessment where those fundamental functional links exist, as they do obviously in some circumstances, but do not do so here. And that may be part of the answer to the 5 schools example to which reference is made, and to which Lord Justice Nugee in particular made reference, I think, from recollection of paragraph 151 of his judgment. If the Free Saturday School used resources and personnel from each of the 5 schools, then they would, one would have thought, be directly facilitating the provision of that school. If, on the other hand, they were simply generating money to support it, then that is the sort of link rejected as insufficient in the Oxfam case. So, my Lord, it's perhaps pretty desperate when an argument is made by reference to an interpretation of a statutory provision in a difficult and complex area, that it's possible to find situations which may be more or less anomalous. Whatever the legislative scheme may be, one may have that, but it is certainly a wholly inadequate basis, even if there were practical issues, and we suggest the practicalities are the other way, but even if there were practical issues, it's a pretty extreme argument that because there may be occasions when practical difficulties might arise, therefore one cannot, in a rating case, have an assessment that relates to a specific rateable hereditament. What indeed would be anomalous would be a conclusion that charitable relief applies even in relation to premises that do not advance the charitable purposes of the charity, simply because they are premises of the charity, which is overall a charity. Simply illogical to say that what applies generally applies in the case of the particular property. It may or it may not do, and here in our submission it certainly does not. Lord, unless I can assist your lordships further, or somebody screams at me from behind.
Doesn't appear to be anybody screaming from behind, Mr. Gowdy. Thank you very much indeed.
Thank you, Lord.
We're going to take a short break now, just to see where we've got. Probably 5 to 10 minutes. Not enough to encourage you to leave the court. Mr. Gowdy, Mr. Kalinsky, thank you for bearing with us. We've reached a stage in our analysis of issue 1, which means that we don't need to hear either of you on issue 2. So we will now take time to consider and deliver our judgment. And it only remains for me to say on behalf of all of us how grateful we are for the quality of the submissions which we have received, both orally and in writing, and in that context we wish to include those who have contributed but have remained silent during the last day and a bit, who we are sure have made a major contribution as well.
Indeed, my Lord. Thank you.